Good evening, Keith Tebow, FRC Media. Our continuing coverage of the federal trial of former Fall River Mayor Jasiel Correia. Today in court in Boston, we had closing arguments and also instructions for the jury. The jury is scheduled to begin its deliberations first thing tomorrow morning on Tuesday. And I've got a full panel today to talk about what happened on the court day today. We're going to start right below with Dan Medeiros. Dan has been with us. He's from the Herald News. He's been doing a great job with the rest of the crew there, reporting on this. To Dan's left, your right, if you're watching this, is Steve Sabra. He's a local attorney, well known in our region, and he's also been an attorney in a number of cases throughout Bristol County. And in the upper right-hand corner is Kurt Hayes. He's a former prosecutor for the Attorney General in Rhode Island, so he's going to give us a little bit of a prosecution side of things. Gentlemen, thank you for joining me. I appreciate it. How are you all doing?
Good. Thank you for having me.
All right. Very good. Dan, we're going to start with you. You watched the entire proceedings today. It was pretty straightforward, I would venture, in terms of the closing arguments were starting. The prosecution went first with U.S. Assistant Attorney Zach Hafer. Then the defense had its side with Kevin Reddington. And then there was a break for lunch, and then the Judge Woodlock came out and gave some instructions to the jury. I want to take this a little bit case by case. So let's start with the beginning of the day when we saw Zach Hafer provide his closing argument, and what did he touch upon?
Hafer took everything very straightforward, very chronologically. He explained that that's what he was going to do because this case has been so complicated so far. So he refreshed the jurors' memories about every single witness that they had seen, sort of summarized again what their testimony is. And once again, he did everything from the very beginning of all of the.
Oh, unfortunately, we just lost Dan. So I will just take over here. Kurt, as a prosecuting attorney, during your career, one of the things that Mr. Hafer did today, as Dan was alluding to before he left us, was he was extremely methodical in terms of laying out the evidence that was presented to the jury, setting a timeline, if you will, in terms of the two sets of cases here facing the jury. The Snow Owl case, which is the app company that the former mayor ran before he was mayor, and he's accused of wire fraud and filing false tax returns in terms of using investors' money illegally. And, also on the other side, Kurt, on the government corruption side, laying out, bit by bit in a timeline, the allegations of bribery and extortion from those attorneys. Kurt, let me just ask you before I go back to Dan, in your experience, is that, what generally happens in a closing argument on the prosecution side, being very methodical in its delivery?
Yes, Keith. I would say these public corruption cases are very complex, and they usually involve a great number of documents and witnesses. As I'm sure you're probably aware, Zachary Hafer has been chief of the criminal division now for about 3 years. He's been a U.S. attorney for 13 years. And so this is not the type of case that he's unaccustomed to handling. So I think that him being very methodical, going through the documents carefully, and then refreshing the jurors' memories as to what those were in the closing arguments is really an important step, so that you're bringing them back into the evidence and showing them how it all ties in to prove the necessary elements to establish the case that they brought against Mayor Correia. So I'm not surprised by that. And Zach Hafer is a very seasoned, experienced attorney who knows how to present these types of matters.
Yeah. Let me bring Dan back in. Dan, you were talking about how, again, methodical Zach Hafer was, laying out, I guess, first the Snow Owl case, then the government corruption side of things. So I'll let you continue. And I think we're still having problems with Dan, unfortunately. So I'm going to just take Dan off for now. So that was the prosecution side of the closing arguments today. And now I'll bring in Attorney Sabra. On the defense side, Kevin Reddington, as is the case for defense attorneys, they want to try to bring in as much doubt as possible for the jurors to consider. But his approach today seemed to be that he was again looking at the co-conspirators in the case, the co-conspirators who pled guilty, and in exchange for their guilty plea, were chosen to testify in this case today. Is that something that you generally see with defense attorneys, Steve, that they'll tend to muddy the water and sort of deflect blame from the defendant from time to time?
Yes, muddying the water is exactly what defense attorneys try to do, keeping in mind that the most important part in a criminal case from a defense side is the issue of proof beyond a reasonable doubt. So if you're a defense attorney like Attorney Reddington here, one of the things he wanted to do, I think with regard to the snow owl part of the case, was to say, well, what you saw here maybe is not something you would have done, and maybe it's not doesn't make a lot of sense necessarily, but it wasn't criminal. Because in the snow owl part of the case, it's really all about intent to defraud. And on the other side of it, his approach was, and which any defense attorney would try to do, is to focus on credibility or the lack of credibility of the government's witnesses. Mm-hmm. And how do you do that? Well, you look for inconsistent statements, which is part of what he did, pointing out, for example, that prior statements to the grand jury were X versus what the witness testified during the trial was different. You point out, of course, that a number of these witnesses had some type of plea agreement, cooperation agreement, and there was some little bit back and forth about that, whether it was an immunity agreement or immunity from prosecution versus cooperation agreement. Reddington using the term immunity, trying to get the jury to focus on the fact that these guys, these individuals would testify and they'd be somehow immune, and the prosecution responded by indicating that it was more a cooperation agreement, that they had to testify truthfully. So typically, that's what you do in a criminal case on the defense side is credibility, because if you can get the jurors to doubt the believability, the credibility of the testimony, then you're going a long way to show reasonable doubt.
And I know, and I'm going to try to bring Dan in one more time. I know that in terms of what you tend to see, and we saw this throughout the entire trial, of those of you who happen to have seen it on Zoom, the prosecution was always, I would call it during the testimony phase, matter of fact. Here's what we have. Here's this document. Here's what did this person say to you? Where, Attorney Reddington was more of, again, Steve, he was going back to, some of the FBI testimony and some of that inconsistencies, sort of, again, looking at ways to deflect and to sort of, in some ways, look at the evidence and say, don't look here. That's not what's really before you. I'm going to try to bring Dan in one more time. Dan, let me just ask you again, what were your general thoughts in terms of, you watched the whole proceedings today? What were your general thoughts in terms of how both sides handled themselves?
Well, again, you were talking about muddying the waters. That's a lot of what Reddington did in his closing argument. He sort of jumped back and forth throughout the timeline. I know the way the prosecution went very straightforward from beginning to end. Reddington started going backwards at first. He started with some of the later charges, moved on to some of the first ones, went back to sort of the middle, and then back to the end again. I mean, he threw out a lot of names from people who didn't testify. A lot of names only came up in cross-examinations under his cross-examinations, in a way to kind of throw the jury off a little bit.
All right, and unfortunately, we lost Dan. So we will thank Dan for his time tonight. He's having a difficult internet day, I guess. So let me just wrap it up. Some things with the attorneys. Following the closing arguments, there was a break for lunch, and then they came back, and then Judge Douglas Woodlock gave his instructions to the jury, and this was, again, very deliberate. Laying out what the law states in terms of wire fraud and tax fraud in terms of the Snow Owl case, and extortion conspiracy, and bribery on the government corruption side. Kurt, let me just ask you, as a prosecutor, is it sort of your role to I'm not going to say assist the judge, because obviously you don't, but to make sure that and I know there's been some pre-conferences on this, that the judge is clear in your mind in terms of what he's instructing the jury based on the evidence that you present as a prosecutor?
Well, as you know, I was a prosecutor some time ago, Keith. But when I was a prosecutor, it's the instructions to the jury are extremely important. And yes, it is something that you're trying to develop, and then you provide what you believe should be instructions to the judge. Judge Woodlock was very, as is the U.S. attorney, rather seasoned. He's a Reagan appointment from 1986. And so he's not unaccustomed to how to instruct a jury, but it is your duty and your obligation to try and assist the judge in that regard, so that the jury is going back in their deliberations with hopefully all of the important elements that they need to establish in coming to a verdict. So the last thing you want to have is a case overturned as a result of a bad jury instruction. So that's a very important part.
So let me ask you, Steve, as on the defense side, are you looking for something that may be in those instructions that if your client, say, is found guilty on a number of these charges, that you can maybe look for as a topic for potential appeal?
Well, as Kurt mentioned, the jury instructions are extremely important. And when they had, in this case, the conference about the jury instructions on Friday, it's the opportunity for each side to kind of get a feel for where the judge is going with the instructions, and also to make your own suggestions as to what the instructions should be based on what the case law is. And then the other part of the jury instructions that you want to know how the judge is going to instruct the jury, because sometimes in your closing argument as a defense attorney and probably as a prosecutor as well, you might try to incorporate some of what the judge is going to instruct the jury, some of the language that he or she is going to use in instructing the jury when you make your closing argument. And the typical thing, of course, is the judge always instructs the jury about proof beyond a reasonable doubt, and how each element of each crime has to be proved by the prosecution beyond a reasonable doubt. And then the last part of it, as Kurt and you mentioned, is this issue of appeal. If there is a conviction, oftentimes the grounds for appeal can be found in what jury instructions were given to the jury.
Yeah, very interesting. All right, let's talk about the next steps. As I said, the jury will get this case and start the deliberations first thing tomorrow morning. I'll ask Kurt first. Obviously you don't know how long a jury will be out. Give me both of you. I'll start with Kurt. Give me a little bit of a background in terms of, how quickly you've seen juries come back. And, there's 24 counts here too. So there's quite a bit for them to go through. And, you would think that it would take them some time, but I guess that's not always the case. So Kurt, let me start with you in terms of some experiences you've had with juries in terms of the length of time they've been out.
Well, generally speaking, the quicker they come back in a criminal case is not usually a good sign for the defense. But you're absolutely right, Keith. It's so hard to predict. You just don't know what the jurors are thinking. I've tried cases where jurors are smiling and giving me every indication that they're on my side, only to find out later on that they were one of my most vehement opponents. So it's very hard to predict, but with a 24 count case, a lot of jury instructions, a lot of evidence, I would anticipate that it's going to take this jury some time to get through it. And
All right, I kind of lost Kurt there for a minute. Your still video is there, but your audio dropped out. Steve,
Oh,
what about
sorry.
you? That's okay. No worries. That's why it's the internet. It happens. Steve, what about you in terms of some experiences you've had in terms of when juries come back?
You know, it's very, very hard to predict. I can recall one case where I basically almost didn't get a chance to get out of the courtroom when the jury came back with a not guilty. I've had other cases where I thought should have been decided really quickly by the jury, and it took them a while, and they found the person guilty. So it's very, very hard to predict. But I agree with Kurt, with a 24 count indictment and all the evidence, it would almost be shocking if they came back quickly. And to me, it wouldn't surprise me if they took a couple of days to go through everything, because with a 24 count indictment, all the elements of the crime, all of each crime, and all the not only there was some documentary evidence, but all the testimony, it would seem to me that it would take some would take some time for the jury to come back with a verdict. And you know, without getting into what the verdict's going to be, it wouldn't be surprising to me if there was some type of, you know, some not guilties and some guilties. To my experience, juries, if they seem to try to compromise somehow.
Yeah.
But we'll see.
Yeah, absolutely. And again, they start tomorrow at 9:30 in the morning. And I guess Judge Woodlock said at the end of the day today, I did happen to see this, was that, you know, he's looking, if it's past tomorrow, that they're looking sort of like a 9 to 5 type day for the jury, unless they're making some, you know, significant headway, and they may extend, you know, the end of the day to continue their deliberation. So we'll just have to wait and see. And I do want to bring Dan in one more time to basically say thank you, Dan. I appreciate your time. We've had some internet issues. I'm sorry you couldn't finish your time with us today, but I do appreciate your time. And I just want to let everyone know that here at FRC Media, no worries, Dan, don't worry about it. Here at FRC Media, we hope to provide extensive coverage when the verdict does come through. Hopefully, I'll be joined by these two fine attorneys, depending on their schedules and when things play out. But I just invite you to continue to follow FRC Media as we continue to provide coverage of the trial of former Fall River Mayor Jasiel Correia. So Kurt Hayes, Steve Sabra, Dan Medeiros, thank you for your time. Have a good night. We'll talk again soon. I appreciate it.
Thank you.
All right. And thank you for joining us today here on FRC Media. Have a good night.